Hello, everyone. My name is Huang. My English name is Crystal Huang. I come from City University of Hong Kong, and today I'm very happy to share with you my article. And I begin to share the screen. And the passage is factors influencing the successful rate of pre-litigation mediation in China, an empirical study based on mediators and case parties. And this study used both qualitative and quantitative data to demonstrate that the case types are not only one affecting the successful rate of pre-litigation mediation in China, is that it's only a symptom. And other factors are also at play, including the expense, the duration, the protections of confidential information, and also the friendliness of the party. In order to determine the variables that affect pre-litigation mediation successful rates, I use qualitative and quantitative methodologies in this research. And the study's result shows that by the use of intelligence technology in pre-litigation mediation, the general public in China is satisfied with the current mediation resources available. Therefore, Chinese courts should focus on resolving other issues that can improve the successful rates of pre-litigation mediation. And as you can see, pre-litigation mediation refers to a consensual process in which the parties to a case come together to settle their differences amicably with the assistance of an impartial mediators before the formal filing of a lawsuit. It reduces the number of disagreements that proceed to court and lowering the cost of the legal system. So my research is focused on the cases which from January 1st, 2021 to the same year, November 23rd. There are about 5,095 cases in the court are studied. Among them, about 7 kinds of the cases are studied deeper, and each category can be seen in the table below. And as you can see, the contract and the default cases had the highest mediation rates, which are 26 and 31 respectively. And for motor vehicle accident liability disputes, the number is 22% of them are successfully mediated. And the successful rate of mediations in commercial issues, which surprised me, is the lowest, 0%, with none of the 109 cases are successfully settled. So I think there may be other factors that influence the successful rate of mediation. That is, other factors may be at play when the case type just as a symptoms of the impact. So I conclude the existing literature. I study a lot of passage, and I believe they have the following limitations, which is the conclusions were reached with a solid evidence. On the one hand, Chen Weixing claims the social status between the plaintiff and defendants greater, the mediation rate of the case is lower. However, this article challenges his conclusion. I argue Chen's recent assertions have been supported by subsequent small-scale comparisons of data, which means that it is not that accurate. And on the other hand, Zuo Weiming only undertakes an empirical analysis in the first half of his paper, and he didn't do a lot of empirical study on the success or the course of mediation's success in the second half of his paper. And Chen Weixing's study is based on the secondary data collected, possibly by some court statistics, which means the results may vary from year to year and may be influenced by some preferences of different jurisdictions. And Qian Dajun come to a conclusion that cases involving marriages, families, and inheritance are better suited for mediators. Contract disputes is less appropriate for mediation. However, this article shows that the successful rate of contract mediation is relatively high, which is contrary to his conclusion. So my research idea and experiment designs that 2 empirical studies were conducted and 1 for qualitative study through 10 pre-litigation mediators, and the other is the qualitative study for the parties, which includes plaintiffs and defendants in mediation. And study 1, we undertook in-depth interview with mediators to ascertain which has the greatest influence on the successful rate of pre-litigation mediation. And next, I conducted a survey on 12 mediators in Court G in response to the above view and come up with the following data. So as you can see, the 12 mediators just vote for the opinions listed in this table. And study 2 is the conduct of the questionnaire survey. Well, I think the qualitative investigations, which I mentioned above, are important. So I just incorporate it into the questionnaire design to have a further testing. I use an electronic questionnaire to study the litigants in study 2, and these people were guided to finish a questionnaire. I conducted 200 interviews during the course of 3 months. I collected 173 valid surveys. And after compiling the surveys, I conclude the following conclusions about the hypothesis. And as you can see, these factors are listed, and you can see not only the case time matters, these factors are also playing an important role. And I just can just conclude and separate them into different categories like favorable elements. For example, the highest one, the length of litigations, critical, and favorable preliminary evidence. As you can see, the hostility is also useful and important. And the unfavorable preliminary evidence, where you can see the familiar with each other, also plays an important role. And insufficient evidence for elements, you can see the educations and legal background have no influence, no connections to the successful rates of mediation. So I have some suggested solutions for the future litigation mediation for the courts. For example, the appointment of mediators who are familiar with government policies and current business administration issues should be introduced to the courts to solve the lower mediation rates of the commercial cases. And also the creations of a strong litigation mediation confidential system. And also the mediator should gain a better understanding and a deeper understanding of the evidence law to better guide litigants. And also we should reform the litigation fee system and to have a long run and more distinct strategy in the design of the lawsuit expenses should be better adopted in the future. And also we should ease the restrictions on how long the trial period can be and ease the burden of the judges. Finally, I think the significance of the study is that first, in response to earlier research findings and fills some research gaps on pre-litigation mediations and advanced academic knowledge. And finally, it provides some solutions and fits several issues. I hope these articles will prompt the academic community to consider what can be done in the current climate of ADR, for the mediation, and advanced pre-litigation mediation in China, which had gained popularity but still needs more investigation. And I think this article is only a start. Thank you. This is all of my sharing. Thanks.